Good morning, everyone who has joined for the second part of the annual online conference of the European Union Forum of Judges for the Environment. Welcome and hello from Brussels in Belgium. My name is Farah Boukel and I am in charge of the secretariat of this organization, and I work as an assistant in environmental law at the University of Ghent, also in Belgium. Thank you to our speakers and all the participants for joining today's conference on the global and urgent matter of air pollution. I will briefly introduce you to our forum for those persons who did not attend yesterday and do not know our organization. I will cover some logistical issues and then turn it over to President Luc Lavreysen, who is going to moderate today and introduce you to our speakers. The objective of the EU Forum of Judges for the Environment is to strive for a better implementation and enforcement of environmental laws by training judges in environmental law and by sharing case law. We are a network of around 100 judges and courts in 40 different countries, and membership is open to all courts or judges interested in environmental law. And these can be judges or courts in administrative, criminal, or civil law at all the levels of the judiciary. You can find an overview of our activities, reports of past conferences, a treasure of documents and links on our new website, EUFJE. You can also find a program there for today and a draft summary report of Dr. Katalin Szuliok on air pollution law. Now, let me explain a few logistic issues. You, as an attendee to this webinar, can only view and listen to the presentations. You can use the chat box for chat messages or for alerting us about technical issues. And please write your questions for the speakers in the Q&A box. Our moderator, Luc Lavreysen, will then have a look at them and submit your questions to the speakers. We will have a discussion at 11:45 until noon. If necessary, if you want to intervene, I can promote you as a speaker, as an attendee. Just raise your hand then in the chat or in the Q&A, and I can give you permission to speak if necessary. We will have the General Assembly of our network at noon, immediately after the webinar. So for the members, please stay, and other persons, please leave the webinar because we are having the General Assembly. We are recording this conference because we would like to share it on our website, and we would like to give persons the opportunity to watch it after the conference. The views expressed by our speakers are their own views, not the views of our network or of the European Commission, who is supporting our activities. Now, I am pleased and honored to introduce you to Luc Lavreysen. He is the president of the EU Forum of Judges for the Environment. He is also the president of the Constitutional Court in Belgium. He is a professor in environmental law at the University of Ghent. And Luc, the floor is yours.
Thank you, Farah. So also welcome for those participants who are new and were unable to participate yesterday. So this morning we will have 3 speakers. The first one being Dr. Katalin Szuliok. And as last year, she agreed to draft the general report based on the questionnaires which were filled in by our member judges. I think in total we had 16 of those reports. And because she did a fantastic job last year, we asked her to do it again this year, and she accepted to do it. So the second speaker will be Christophe Sobota, and the third speaker, Thomas Weber. I will introduce them later on. If you have questions, so as Farah said, put them in the Q&A box, and there will be a discussion at the end. So also the questions for Dr. Suliok, please keep them, put them in the Q&A box. Dr. Suliok is working with LT Law School in Budapest. LT is an abbreviation of a very long Hungarian name. So please, Katalin, you have the floor for your presentation.
Thank you, Mr. President. Let me share my slides. Oh, excuse me a minute. So here they are. So good morning, ladies and gentlemen. It is a real pleasure for me to be with you here again this year and reporting on the questionnaires collected from judge members of this organization regarding the state and trends in domestic air pollution litigation. So in the following few minutes, I will first give you an overview and the background to this year's questionnaire and to the summary report. Then I will address the trends in domestic air pollution litigation that I could discern from the answers of judge members. And then at the end, I'd like to address briefly the significant domestic laws that are also at play before national courts in domestic air pollution litigation besides EU law. So the questionnaire contained 10 overarching questions relating to 4 main issues. 3 were the main pillars of EU air pollution law, and the 4th section was dedicated to domestic law. So the first section concerned the ambient air quality directives of the EU. The second on the directive on reduction of national emissions. And the third concerned the secondary sources of EU law with regard to EU vehicle type approval rules. And the last section, as I've mentioned, was dedicated to domestic laws. You can see on the slide the more specific topics that have been interrogated by the questionnaire with respect to each of these EU laws. We received inputs from 16 judge members of the European Forum of Judges for the Environment, and these inputs provided the basis of the summary report, which makes some analytical remarks on the current trends. In the interest of time, I will now only present you some of the main findings of the summary report, but in case you are interested more in depth in any of these issues, please feel free to read the entire report, along with the national reports of judges. All of these are available on the website of the EU Forum of Judges for the Environment, on the website of EUFJE.org. So first, let me give you some general remarks on the sources and state of air pollution, which ultimately drives domestic air pollution litigation cases. The questionnaire revealed that improving air quality is a cross-cutting challenge for states, although the gravity of this problem varies among them, as we have also seen this on the chart of the European Environment Agency yesterday, presented by Martin Adams. Yet the overwhelming majority of respondents reported exceedances in certain pollutants. Only 5 of them reported that they only experienced minor or sporadic problems with exceeding limit values of EU directives. That's true that each state faces country-specific drivers of air pollution, so they differ also in terms of the main pollutants and their most significant sources. Usually we can say that NO2 emissions, particulate matter and fine particulate matters concentrations are among the chief problems. And typical sources include tailpipe emission, household heating, or industrial sources in some countries, such as the electricity generating sector. For certain states, the problem is also rooted in transboundary sources of air pollution. Such a problem was reported from Cyprus, Denmark, and the Czech Republic. And some jurisdictions, there are some more serious problems with the air quality monitoring network, which is supposed to provide the public with accessible real-time data on the concentrations of more main pollutants. Serious and structural deficiencies have been identified in the data measured in the Romanian monitoring network, and Slovakia also reported problems with compliance with the EU law requirements. So against this background, let me now turn to the implementation of relevant EU directives on the national level. The national reports of judges have revealed that only 4 states have enacted stricter or complementary air quality standards besides EU pollution law requirements. This means that EU law provides the backbone of domestic frameworks for combating air pollution, which makes the proper judicial enforcement of EU law particularly consequential for improving domestic air quality. This sector is also characterized by a high number of infringement proceedings, mostly relating to the Ambient Air Quality Directive. Only 3 judges reported a lack of infringement proceedings against their respective states, while 7 states have seen several, 2 or 3 infringement proceedings, and 6 were targeted in 1 infringement case in the last decade. And some of these cases have also reached the Court of Justice, and some of them are still pending. The Ambient Air Quality Directive is most heavily litigated also before domestic courts. The summary report details cases reported from 12 jurisdictions. The Dieselgate scandal also generated various proceedings before national courts, which I will refer here to as defeat device litigation. And in the following minutes, I will now talk a bit more about these 2 types of domestic cases. Cases brought under the Ambient Air Quality Directive, and later on I will elaborate on a bit more on the defeat device litigation. So first, let's see who are the typical claimants in cases featuring the Ambient Air Quality Directive. The most typical claimants are NGOs. As we have also discussed it yesterday with Ms. Manfredi, international and domestic NGOs, sometimes their alliance, are key actors in enforcing the adoption of meaningful air quality plans on the domestic level. The NGO-driven nature of such litigation has, however, its blind spots. First, in some countries, expert NGOs are only present in the capitals or big cities, but not in the rural areas where, in fact, the most pervasive air pollution occurs. For instance, in the Czech Republic, 2/3 of all environmental cases brought by NGOs relate to Prague and Brno, yet the most polluted region of the entire EU, namely Silesia, has only seen a couple of such court cases. Second, securing enough funding for civil society organizations can be challenging in many states, which we see that it directly impacts the number of air pollution claims brought to the courts on the domestic level. Besides NGOs, municipalities can also be important rights holders in domestic air pollution litigation. These rights can be even invoked against the government sometimes. The city of Ostrava, for instance, filed an action against the Czech government for its failure to abate the desperate air quality of its region. And the Supreme Administrative Court found that the right to self-government was at stake, and Ostrava was also entitled to defend the rights of its citizens against the government. Of course, the standing of municipalities is a double-edged sword. Sometimes municipalities can use this entitlement to challenge air quality measures, as it occurred in the case of the Madrid Central litigation. In Madrid, it was the new mayor who asked the courts to withdraw the low emission zone enacted by its predecessor in the central area of Madrid. Besides these actors, traders associations and ombudspersons are also acting as plaintiffs in certain jurisdictions. And sometimes scientific institutions may also be involved in domestic litigation. For instance, the enlargement of the Václav Havel Airport in Prague was challenged by 5 municipality districts, 2 individuals, and 4 institutes of the Czech Academy of Sciences. Last but not least, private individuals are also appear as plaintiffs. Typically, they file tort claims with courts demanding compensation for developing certain diseases due to air pollution. In France, for instance, such a case was reported from the Montreuil Administrative Court, which recognized the fault on part of the French state for passing only inadequate measures to tackle air pollution in the Ile-de-France region. Yet the court dismissed the compensation claim of the individual because it did not find a requisite direct causal link established between the air pollution and the respiratory disease developed by the claimant. So we can see on this chart how air pollution litigation brings together a matrix of heterogeneous actors, adding another layer of complexity to air pollution cases. The questionnaire also specifically interrogated the subject matter of domestic proceedings under the Air Quality Directive. The bulk of national litigation in such cases revolves around challenging the content of air quality plans. As a preliminary issue in such cases, courts have to decide about the standing of NGOs. The Court of Justice of the European Union adopted a clear language in the Janacek case, requiring that, and now I'd like to quote, natural and legal persons must be in a position to require competent authorities to draw up an action plan, if necessary, by bringing an action before competent national courts, end of quote. So despite this very clear language, in certain jurisdictions, NGOs are still denied standing when they would like to challenge the content of air quality plans. In Hungary, for instance, the NGO's action challenging the inadequate content of air quality plan of Budapest has been dismissed by the first instance court for the lack of standing. The claimants just have submitted their appeal to the Supreme Court, so we shall see how this will play out in the future. But the same problem also exists in Poland, which is currently subject to infringement proceedings for not granting NGOs access to justice rights in air pollution cases. Nevertheless, the majority of jurisdictions are willing to review the content of air quality plans in a substantive way. In fact, courts in the Czech Republic, France, Romania, Slovakia, and the UK all quashed such plans for having insufficient content or stipulating only unrealistic, unquantifiable, or ineffective measures. Belgian courts have also reviewed the scientific basis of measures and ordered a new air quality plan to be prepared that considered also data gained outside of the fixed measurement stations. This finding is particularly important for the potential significance of citizen science projects in domestic air pollution litigation. The Belgian report also describes such an initiative in which 200,000 citizens measured NO2 concentrations near their homes and detected exceedances in many cases. Citizen science projects, therefore, can be especially important tools to identify locations where the population is most exposed to enduring air pollution, and thus where monitoring stations should be sited. This information would be a valuable source of data for national authorities in choosing the appropriate locations for sampling points. Another set of domestic cases revolves around how to choose the location of such sampling points. This was one of the questions in the famous Cranes preliminary reference made by a Belgian court. Christophe Sobota will give you more detail about this case in the coming presentation and about especially the preliminary ruling judgment of the Court of Justice in the next presentation. So furthermore, German administrative courts were also asked to rule on the legality of banning diesel vehicles. The Federal Administrative Court made clear that a ban is lawful if it is the only way to render the time of exceedance as short as possible, as far as the ban is proportional. Currently, there are many similar proceedings pending before German courts that also concern the fine-grained questions of the proportionality assessment under German law. Lastly, the directive was also relied on by the Bucharest Tribunal in Romania in a case concerning the lawfulness of denying the deforestation permit from a private landowner. The domestic court in this case found that the goals set out in the directive provided a legitimate aim for interfering with the right to property of the landowner. Many jurisdictions hear claims seeking to challenge the permit of an individual development project that may cause exceedance of air quality standards. Domestic laws and domestic litigation and judicial practice are saliently divergent on this point, in light of the national reports submitted. Estonian law, for instance, precludes individuals from filing such a challenge against an individual permit. Belgian law also does not imply a general prohibition on granting a permit to a project that would cause additional air pollution, nor does it impose a compensation obligation for the incremental pollution resulting from the project. The Council of State in Belgium held that compliance with the limit values of pollutants should only be assessed in relation to a given zone or agglomeration, but not in relation to a specific urban development project. In contrast, certain domestic laws grant individuals the right to hold such projects. Under Czech law, individuals may challenge respective permits, though the courts set a high bar for allowing such individual claims to prevail. For instance, Czech courts would balance the benefits of the project against its environmental impact, and the claim can only succeed if the emissions are disproportionate to the local circumstances. UK courts also heard such claims, but they upheld the permit granted by the authorities with reference to the vital discretion of authorities in authorizing individual projects. In this way, a UK court dismissed claims alleging that building a fourth runway to the Heathrow airport would undermine the UK's obligation under the Air Quality Directive. And finally, Dutch law adopts a third approach and stipulates a statutory requirement of making a significant contribution to air pollution. And only those permits can be challenged where the respective development makes such a significant contribution. The Dutch legislation also sets forth a presumption of the lack of such a contribution for certain even mid-scale development projects. So another section of the questionnaire concerned the challenges national courts encounter in enforcing their judgments in air pollution litigation. The respondents in this respect repeatedly mentioned difficulties in ensuring compliance with their action forcing judgments, where they actually compel governments to take timely and effective action. The Romanian report noted the limited judicial toolkit they possess to ensure that adequate action is actually taken following a court order, but the problem is more pervasive and is present in many other jurisdictions as well. For instance, in France, the Conseil d'État even had to impose a 10 million euro penalty payment on the state until the proper execution of its judgment, requiring the revision of an air quality plan. UK courts also had to adopt an unusually flexible supervisory jurisdiction in air pollution litigation cases, which allowed the plaintiff to bring the matter back before the court if the defendant was falling short in its compliance. And lastly, German authorities were also reluctant to enact diesel bans, despite the Federal Administrative Court's repeated judgments ordering the local authorities to include this measure in their air quality plans. A distinct thread in domestic case law relates to claims seeking the withdrawal of air quality measures before domestic courts. Despite the wide variety of such claims in national jurisprudence, we can say that none of these attempts have been successful so far, as relevant domestic judges upheld all of these air pollution abating schemes. These policies usually contain ambitious emission cuts, which have met with opposition not only from the industrial actors, but sometimes even from the wider public. Low emission zones, for instance, have been created in Brussels, Bucharest, and Madrid, and all of them were taken to courts for being contrary to the right to property, or being ineffective, or violating the allocation of powers between the federal and the state level government. Yet the courts dismissed all of these challenges. The legality of diesel bans, as I've alluded to before, were also challenged before German and Italian courts by individual car owners and even by traders associations. These bans were again also upheld by the courts. And in Poland, private persons demanded the annulment of the local authorities' ban on the use of coal for household heating purposes with regard to their polluting effects. And these statutory limits were again found to be lawful. The questionnaire also contained a question relating to the sanctions provisions member states adopted under the Air Quality Directive, because Article 9 of that directive requires that member states determine effective, proportionate, and dissuasive penalties applicable to infringements of national provisions adopted pursuant to the directive. In most countries, sanctions can be both administrative and criminal in nature. Yet the countries differ as to whether legal persons and public entities can also be subject to criminal sanctions. Spanish law, for instance, recognizes the autonomous criminal liability of legal persons if the corporate conduct also constitutes an infringement of environmental administrative law. Yet the Spanish criminal code excludes local and governmental authorities from the scope of criminal liability. Under Belgian law, however, so Belgian law foresees and allows the criminal liability of public entities, such as the federal state of the regions, to be declared, yet these entities cannot be otherwise sanctioned under criminal law. Furthermore, criminal liability of individuals may also be possible, as we have seen in Romania, for instance, where the applicable sentence ranges between an imprisonment from 3 months up to 5 years. And lastly, administrative sanctions are also possible for private and legal persons, and in certain jurisdictions, even for public entities. So let me now turn to the defeat device litigation generated by the so-called Dieselgate scandal. I'm afraid all of you are quite familiar with it. These litigation and claims arose from the fitting of defeat devices, so-called cheat softwares, by certain car manufacturers in diesel passenger vehicles. These claims are various in terms of their legal basis and legal natures, as you can see on this slide. Some claims are criminal in nature, and such criminal proceedings are pending in Germany against car manufacturers, against the managers of respective companies. And the criminal investigation is also ongoing in Belgium. Administrative fines have also been imposed on manufacturers in Germany. Moreover, damage claims have been filed by individual buyers with German courts. And further to that, Belgian, Italian, Portuguese, and Spanish consumer protection organizations have filed a class action for damages before the Court of First Instance in Brussels against Volkswagen. The out-of-court settlement in this case has failed, so the proceedings is currently pending. Investors may also have claims against the companies. A group of Belgian shareholders, for instance, sued for a compensation of 1.4 billion euros for their losses suffered on their purchases of Porsche and Volkswagen securities. This case is currently pending before German courts. And finally, in the UK, car owners brought a group action against manufacturers on the basis of fraudulent misrepresentation contract law claim. And in the last section of my presentation today, let me briefly address domestic laws that are frequently relied on before the courts, or which are significant tools to abate domestic air pollution besides EU law. So constitutional provisions granting a right to a healthy environment is a frequently invoked legal avenue in many states, for instance, in the Czech Republic, France, Romania, or in Spain. At the same time, certain human rights standards can also be invoked to limit the inspection powers of authorities. For instance, the new inspection powers of the Czech Environmental Protection Authority to enter private premises for inspecting solid fuel boilers as potential sources of air pollution have been challenged before the courts for violating the right to privacy. The Czech Constitutional Court, however, ruled that the restriction was necessary to protect the right to life and health and was found to be lawful. Permitting requirements can be also a major tool to improve air quality. Finnish law in this regard stipulates a minimum distance requirement for permitting major stationary sources of air pollution. This practically means that rock crushing and graveling cannot be carried out within a minimum distance from where most vulnerable groups reside and stay, such as hospitals, kindergartens, schools, and residential homes. Besides creating low emission zones, which we've seen that is a frequently applied tool to abate traffic-related emissions, another frequently featured tool is to limit idling times. Finnish law, for instance, prohibits idling time of motor vehicles over 2 minutes. And the UK law also allows for penalty notices to motorists who leave their stationary vehicles engines running unnecessarily. Lastly, imposing CO2 taxes on vehicles running with fossil fuel is also, or could be, an also efficient way of reducing emissions. Yet, according to the 2020 survey of the European Automobile Manufacturers Association on the use of such taxes in the EU, we see that such taxes are far from being fully embraced by member states. Estonia, Lithuania, and Poland decided not to impose such a tax, according to the survey, while others apply carbon tax, but those taxes frequently target CO2 emissions only indirectly and or are not applicable uniformly to privately owned and company cars. So let me now briefly summarize some of the main messages of this year's questionnaire and the summary report. So we see that there are still open questions before certain jurisdictions regarding the standing of individuals and the enforceability of air quality plans before domestic courts. The majority of jurisdictions, however, are willing to review the adequacy of the content of air quality plans. The remedy they may grant, however, in these cases depends on national procedural and substantive laws and the technical complexity of the cases. Even if the courts are willing to review air quality plans in a substantive way, they experience difficulties in ensuring compliance with their judgments that require timely and effective measures to be taken by the government at all levels. And as we have discussed with Ms. Manfredi yesterday, the role of NGOs cannot be overstated in strategic air pollution litigation. The saliently NGO-driven nature of domestic air pollution litigation suggests that the reach of EU law ultimately depends on access to justice rights guaranteed on the domestic level. While it is also, what is also apparent from the answers received to the questionnaire is that domestic courts are often the final arbiters of air quality policies. As such, measures are routinely taken by various actors to domestic courts. The fate of ambitious emission reduction policies is ultimately lies in the hands of national judges. All in all, the questionnaire depicted the landscape of current domestic air pollution litigation as being a matrix composed of heterogeneous actors, various normative bases, and sometimes expressly conflicting economic and legal interests, all to be tackled by domestic courts. So we see that it is no way an easy task. Thank you for your kind attention, and I'm looking forward to receiving your comments and questions during the Q&A session or via email anytime later on. Thank you.
So thank you very much, Dr. Suljok, for this comprehensive, very clear, well elaborated summary report. So as said, if you have questions today, put them in the Q&A box. Maybe you mentioned that we will publish also the national reports on our website. So normally we will give 2 or 3 weeks time to our members to have a final look to their contributions before we will publish them on the website. And we ask also our members to have a look to your written report to see if everything has be well understood, and if there are some updates to make to inform us and to inform Dr. Suljok. So thank you very much. Now let's turn to the Court of Justice of the European Union in the person of Christophe Sobota. He is working in the cabinet of Advocate General Juliana Cocotte, who is in charge of a lot of environmental cases with the Court of Justice of the European Union. I understood that if the conference would be held in Leipzig, she would become in person, but digitally she had the bright idea to ask it to Christophe, which we know from earlier conferences, to present to us recent developments in the jurisprudence of the Court of Justice of the European Union. So, Christophe, the floor is yours.
Well, thank you for this kind introduction. I'm trying to share my screen with you. There we are. Okay, so I hope you're seeing it now. Well, I'm talking about relevant case law of the Court of Justice. Oh, I have to find out how to get to the next screen. Okay. This is my standard disclaimer. I guess most of you already know about the Advocate General. She's a member of the court. She prepares opinions independently and advises the court this way. She does not participate in deliberations, and therefore she does not know what the court was considering when they were deciding on certain cases, and therefore she can't tell you. I don't know either. So whatever I'm telling you about the judgments is only what I'm reading from them. I'm helping her with drafting opinions. I'm very proud of the opinions that we are doing, but you should be aware that an opinion is not a judgment. Only the judgment has the authority of the court. So if you want to base yourself on something reliable, you have to find it in the judgments. On the other hand, you should read the opinions because they should help you to better understand the case and the legal issues that were discussed. And perhaps they might also give you some ideas about questions that you could ask the Court of Justice because they have not yet been treated in the judgment that followed the opinions. Okay, that's what I'm going to be talking about today. First of all, I'll talk about a little bit about the Kreinest case. Then I'm talking about enforcement. There are two ways of enforcing air quality law. That's top-down enforcement and bottom-up enforcement. I will also try to address a little bit the question what air quality law and individual projects have to do with each other. And I'm not very optimistic that I will be able to touch upon the Dieselgate cases that are currently pending, but most of them are not that interesting yet. Anyway. Okay, to start with a short overview of the rules that apply. One thing that is important to keep in mind is that not all air quality issues are covered by the Ambient Air Quality Directive. Only some pollutants are covered. The most important ones up to today, PM10, dust, particles, and of course nitrogen dioxide. Once the limit values are breached, another obligation kicks in, namely the obligation to adopt air quality plans that should aim to keep the period of exceedance as short as possible. Of course, the difficulties there lie in the details and in the technical side of all of this, whether these plans are effective or not. These are the problems that confronted the court up to now. I understand that the issue with these particles is in particular relevant in cities where wood or lignite, brown coal are used for heating. We had cases in Bulgaria and Poland on this. And if you hear the word heating, you can already easily imagine the difficulties of coping with this problem, because in principle you would have to change the heating systems of habitations. And these are major investments for private parties, so it's very, very difficult to do this. And it takes time. NO2 is more a problem for richer member states. I think it's mostly in cities where you have lots of automobile traffic, and there in particular diesel engines are a problem. And of course, if you try to do something about diesel engines, you're stepping on a lot of toes of people, and therefore it's also very sensitive. Compliance requires severe restrictions, but also a balancing of the objectives and of the interests. And therefore, the follow-up question is to what extent this can be judicially controlled. I don't think that we've really gone into depths there already in the Court of Justice. Okay, the Kreinest case is the first we're talking about. People in Brussels challenged the placement of sampling points in Brussels, and the reference then asked us whether this placement actually can be challenged and how they should determine whether a limit value is exceeded. can they do an average of all the sampling points, or do they have to look at the highest value? The court dealt with both questions. Of course, you know, persons can rely on a directive, in particular if it aims to protect public health. Persons concerned, that's an important point. The directive specifies the EU's obligation to protect the environment and public health with regard to air pollution. That's perhaps another interesting point, that there is an obligation on the part of the EU to protect these objectives. And then we come to this classical question of direct effect. Direct effect requires unconditional and clear obligations. And here, with regard to the placing of sampling points, you need to undertake a complex scientific assessment to find out where to put the sampling points. And this, again, implies some sort of discretion on the part of the authorities. And this would, in principle, in the classical jurisprudence, be a strong argument against the invocation of this obligation. However, the court highlighted that even if there is discretion, the limits of discretion must be enforced and verified by the courts. And that's perhaps, it's not the first time that the court has highlighted the limits of discretion, but that's something that this case brought again to the fore and should always be kept in mind if you are confronted with obligations that are not clear and unconditional in all circumstances, but where there may be situations before national courts where it is clear that the limits of discretion have been breached. In this case, it was the limits of discretion concern whether the national authorities really identified the sites where the highest values could be found. And therefore, they need to identify these sites. They need to have proper scientific basis to identify these sites. And if they haven't identified these sites properly, then there might be a breach of the limits of discretion, and they might have to start again with this exercise. The next question, of course, was how to find out whether limit values have been complied with. The theory advanced by the Belgian authorities in this case was they could do an average of all the sampling points, but you have to be aware there are different types of sampling points. Most importantly, two types. One is the sampling points shall identify the areas where the highest concentrations occur, and the other type of sampling point tries to identify the general exposure of the population. So you might have in one point some kind of average exposure, which might be well below the limit values, and at other points you would have the highest values. And if you do an average of these different measurings, then you will of course arrive at a lower pollution level, but they would not represent the pollution at the highest points. And if you look more closely at the directive, even though there is no explicit rule how to arrive at the identification of exceedance, there are indications that you should identify the places of exceedance, and that means the highest exposure. And of course, the objective of the directive is protection of health. And if you are only looking at the average, then you will certainly miss out the points where health will really be in danger, because there are the exceedances and people are exposed to it. And therefore, the court came to the outcome that the exceedance can result from an individual sampling point. And this is, of course, very important for the effectiveness of these rules. Now we turn to the enforcement of air quality rules. And of course, one way of enforcing it is that the Commission starts infringement proceedings. And we had the first type of approach, which is illustrated in these cases. But these cases only came to the outcome that the court found in a certain year, the air had been bad at some locations. What can you do with this finding? Obviously, it's not good, but you know that there is also an enforcement procedure for infringement judgments. And this requires the verification whether member states have implemented the findings of the court. And how can you implement the finding that at some point in the past there has been an infringement? So this first round of cases was not really very helpful. to enforce ambient air quality rules. The Commission reconsidered and started a new type of case, and the first one of these cases was the case against Bulgaria. There were ongoing breaches over several years for particles, PM10, mostly resulting from heating. And the court and the Commission applied for two findings, and the court found these infringements. The first one is that there is a systematical and continuous infringement of obligations. And the interesting bit about this systematical and continuous infringement is that it can continue into the future. And if it continues after the judgment, then of course enforcement action under Article 260 is possible. And here, of course, the systematic and continuous nature results from the ongoing breach over several years. It's the breach of the same nature in the same areas, resulting from the same sources, and therefore the breach is systematic and continuous. The second foundation of this action was that the plans that Bulgaria had adopted after the breaches had been found were insufficient. Obviously, when you adopt a plan dealing with these issues, a balance must be struck between minimizing the risk of pollution and the various opposing public and private interests. And heating is, for me, a really exemplary case. You cannot prohibit heating with wood or lignite in Sofia, because then the next thing you would have would people probably freezing to death or other consequences that you don't want to have. And so therefore there is a need to do a certain type of balancing. On the other hand, the balancing should not result in negating and ignoring the obligation. The exceedings should be kept as short as possible, and therefore member states need to take appropriate action and do something to speed up compliance. And here in this case, the court said, okay, it's quite clear, because you have this continuous exceedance, it's quite clear that your plans have not been optimum, and therefore there's also a breach of the obligation to adopt sufficient plans. Here we may be in difficult waters once we look more deeply into plans, because the balancing is obviously very difficult to verify in the end. But up to now, the Bulgarian plan clearly was insufficient, and therefore it was quite easy. This approach was then confirmed in another case against Poland, but we haven't yet had a case where the Commission applied for penalty payments or lump sums under Article 260, so we don't really know how far this might go. And then the Commission started a new round of cases, and we had the first two of these already, one against France, where some other arguments were rejected, in particular, the argument that France couldn't do something about NO2 because there weren't sufficiently strict standards for diesel cars was rejected, because they could, of course, have adopted restrictions of traffic to keep diesel cars out of the city centers. And moreover, the court looked more closely at the plans, and it was quite clear there were no specific considerations of the area for the areas concerned, and therefore the plans were manifestly insufficient. Again, the court did not look very deeply into these plans, and they didn't have to look at the balancing that was undertaken, because it was quite obvious that they were insufficient. And we also had a similar case against Romania. And these are the cases that are still pending. Commission versus Italy was referred to Grand Chamber because Italy asked for this referral. We will see whether the Grand Chamber of the court will confirm the current line of reasoning. There should be a judgment very soon, and if the reasoning is confirmed, then of course the other italic cases should be decided soon afterwards. The other three will probably take a little bit longer. For the italic cases, I expect judgments before the end of the year, but I may be wrong. Okay, and now we come to the other branch of enforcement through national courts. And the first case has already been mentioned, Janecek, from 2008. You see this picture of which doesn't indicate very nice air in Munich. Janecek lived near there and brought a case because of breach of the limit values. Mr. Janecek wanted to have an air quality plan. And this posed a big question for German administrative courts, because under German doctrine, general public interest, such as served by plans, is not defended by individuals or NGOs, but by public authorities. And therefore, the German Supreme Administrative Court asked the Court of Justice whether EU law requires that they allow an action by an individual requiring such a plan. The court briefly looked at direct effect and found that the obligation to adopt a plan as such is sufficiently clear and unconditional, and therefore individuals can require such a plan. Moreover, the court highlighted that individuals have a legitimate interest in a healthy environment to live in, and therefore underpinned this obligation or this right to invoke such provisions. This was confirmed in the case concerning the UK brought by Client Earth. Here, the British courts were not really sure whether they could enforce this obligation. They considered it more of a political question, probably because of the difficult balancing that had to be undertaken, but also because of the technical issues involved, and because of the discretion involved in adopting such plans. The court highlighted that there is discretion, but also that the exceedance must be kept as short as possible, and therefore the limits of discretion should be verified. And the court also underlined that courts, national courts, must take any necessary measures, such as an order in the appropriate terms, so that the authority establishes an appropriate plan. The outcome of this you can see here. I won't go into much detail, but if you read these two cases, you see a very detailed examination of technical issues related to plans, responding to the criticism of Client Earth. So we see that this jurisprudence has very much advanced the enforcement of ambient air quality in the UK, and probably also in other member states indirectly. However, in Germany, not all problems were resolved. The German region of Bavaria, where the Janacek case took place, still refuses to ban diesel cars in cities, and the alternatives that they are providing for do not promise a solution in the near future. At least in the past, the plans that they had adopted did not promise a solution in the near future, and therefore the Supreme Administrative Court of the region has already imposed 2 penalty payments of 4,000 euros each, but these penalty payments were paid from the environmental authorities to the regional Ministry of Finance. So you can imagine the enforcement effect of these penalty payments was not very strong, and it didn't change the opinion of the region. They still refused to ban diesel cars, and therefore the Supreme Administrative Court of the region went to the Court of Justice and asked us, what shall we do now? In particular, is there an obligation resulting from EU law to place officials in coercive detention unless they adopt the necessary measures? Coercive detention is quite a strong incentive, you can imagine. So what did the court say to this? Well, you know the starting point. Member states enjoy procedural autonomy if there's nothing laid down in EU law, but this autonomy is subject to the principles of equivalence and effectiveness. We all know that there are no specific rules to enforce air quality law against member state authorities in EU law, so we had to look into member state law. And the court focused on the principle of effectiveness and effective judicial protection, and stressed that if you have judgments that cannot be enforced, then the essential content of the right to an effective remedy is violated. And this is valid in particular if the judgment is about health. So something needs to be done. And the first thing that you can do is, of course, interpretation of conformity. In German law, there is the possibility of imposing coercive detention, but it's limited to civil law. At least it's only explicitly foreseen for civil law. There is a reference from administrative law to civil law that could be interpreted this way, but up to now in Germany, it's very, very contentious, and as far as I know, it has never been transposed to administrative law. So this is a question of internal law. It's up to German courts to find out whether they can do something with interpretation in conformity. If it is not possible to interpret member state law in conformity, then of course member states are under an obligation to disapply any internal provision that is contrary to EU law. The court did not explicitly say that this is limited to cases brought against the administration, but this usually is a side element of this. Usually you cannot disapply internal provisions that protect private parties, at least as far as the enforcement of directives is concerned. So there are already limits in this idea, but in this case the limits are more explicit. And accepted and highlighted that there is a limit resulting from the right to liberty, which is in the Charter of EU Fundamental Rights. This right to liberty must not be infringed. So first of all, there must be a legal basis for coercive detention in member state law. And this, again, of course, is for member state courts to decide whether there is a sufficient legal basis. And then we are again at the point of reference from civil law to administrative law. And even if you have a legal basis for coercive detention, another question pops up, because a coercive detention must be proportionate. And it is not proportionate if there are less restrictive measures that can be adopted. And here in this case, one issue might be that you might consider are higher penalties against the administration and penalties that are not paid to the administration, but to other recipients. And here we are in an area where disapplying opposing member state law might be much more interesting. If you have a rule that says that penalties have always to be paid to the administration, you can easily disapply this, because it's not about the protection of private parties in this case. And in the follow-up to this case, we can already see that something like this happened in Germany. It didn't happen in Bavaria because the Bavarian authorities recently adopted new plans, and now the Bavarian courts will have to look whether these plans are sufficient or not before they can go to the stage of enforcement. But in the neighboring region of Baden-Württemberg, the courts ordered a one-time penalty, a higher penalty of 25,000 euro to be paid not to the region, but to a medical NGO. And apparently now the regional government intends to comply with the existing judgments. And even more interesting, there's this judgment of the French Council of State that was already mentioned, 10 million euros per semester until clean air is achieved. Here the difference, of course, is that French law clearly allows this method of enforcement. So this is the highest sum that has ever been imposed. French law also clearly allows to choose another recipient than the administration. As far as I understand this case, the recipient of this fine is still unclear. It might have to be decided in the future because, as I understand, the fine hasn't been paid yet. It would probably have to be paid towards the end of this year, and then you would have to decide whether it's to be paid to some branch of the state or to an NGO, or even perhaps to the NGO that brought the case. Another means that could be considered has been developed in Italy. There, a special commissioner can be appointed in place of the administration that refuses to implement a judgment, and this special commissioner can then adopt the necessary measures. But again, this might be something where you need a legal basis before you can do it. Now we come to air quality and the authorization of projects, which is of course a very interesting question. Can individuals or NGOs oppose a project would affect air quality negatively? What if the limit values are already breached? There's no case from the Court of Justice on this issue yet, but there's a parallel case on the Directive on National Emission Ceilings, Stichting Natur and Milieu and others. And this case concerned permits for power stations, coal power stations, which would emit large quantities of pollutants, where the Netherlands had already breached the national emission ceilings for these pollutants. and it wasn't quite clear how the Netherlands would aim to respect the national emission ceilings in future if these power stations were built. So they brought a case, and the Dutch court then asked us whether the directive on national emission ceilings could be invoked against individual projects. The court said no. How did the court arrive at this outcome? Well, first of all, they looked into this issue in the context of the Industrial Pollution and Prevention of Industrial Pollution Directive, which is now the Industrial Emissions Directive. There's a rule that requires that projects should respect environmental standards. The court started by saying, well, an emission ceiling is not an environmental standard. Limit value would probably be considered an environmental standard, but the directive on national emission ceiling did not require the examination of individual projects, and rather it has a general and programmatic approach. The member states should adopt overall programs which should make sure that the emission ceilings are respected nationally, and this would be in parallel to the air quality rules. The court also examined whether the obligation to refrain from activities that would frustrate the objective of the directive on national emission ceilings could come into play here. But again, the programmatic approach was a problem because it is based on member states' discretion how to achieve the national emission ceilings. Of course, if you have one huge project which emits lots of pollutants, you can still comply with the emission ceiling if you stop other projects or other activities that result in pollution. So member states can choose how to comply with the obligations. And therefore, the court said, well, individuals and NGOs should require the member state to adopt an appropriate program to attain the ceilings, but they should not be able to attack individual projects about this. If we look at this in the framework of air quality, we might want to look again into the issue of limits of discretion in authorizing such projects. If a project clearly results in a breach of the limit values, then there might be a limit of discretion that might be affected. But, well, the court has not yet decided on this. And other issues that we might want to look at is if there are already breaches and if there are air quality plans, then I would argue that such a new project would have to fit into the air quality plan in some way. And if the air quality plan starts from the assumption that there would be no new sources of pollution, then of course the permit for a new source would run counter to the air quality plan. If the air quality plan provides for such a new project, of course, then we would have to look whether the project is still within the parameters set up by the air quality plan. So these might be ways to look into new projects under air quality legislation. But still, the focus here would always be compliance with general obligations of the Air Quality Directive by way of the plan. And this would only indirectly affect the projects. I think I'm already near the end of my time. I won't really look into this case, which had a really interesting outcome, saying that new testing methods adopted by the Commission are illegal. But there's an appeal pending in our case. We will have to see what comes out of this. We have an opinion of Advocate General Sharpston on defeat devices. There we also have to wait for the outcome of the court case. It's a very technical issue, but I don't find that interesting. The interesting bits are pending and still away from opinion or a judgment. This Deutsche Umwelthilfe case raises the interesting question whether an NGO can attack the type permit of cars under the Aarhus Convention if there is a defeat device in the car. This appears really, really interesting and would have far-reaching consequences if they could do this. And we have, of course, civil cases on defeat devices pending in our court. One of the more interesting ones asks in substance whether the actual use of the car needs to be deducted from the price if the car is returned. And the court in this case asked whether he can consider himself still sufficiently independent in these cases, because there have been some political influences on these cases, and there has been a circular by the president of a higher regional court in the neighboring region, which recommended certain ways of dealing with defeat device cases, and this judge then thought that this might affect his independence. So we will have to wait what comes out of this. And anyway, I'm at the end of my presentation. I thank you for your attention, and I'm available for questions later on. Thanks.
So thank you very much, Christophe, for this in-depth overview of recent case law on air quality at the Court of Justice of the European Union. Maybe, and that's also for Katalin, for the discussion. Katalin mentioned in her report that there is differences in view on the impact of the ambient air quality directive on the review of projects. You mentioned the NEC, the jurisprudence on the national emission ceilings. So, but maybe a question for the discussion is, would the outcome be different if one has to review a project in the light of the ambient air quality directive, given also the case law, the cry nest, because there the court says this limit values should be at any time, everywhere respected. Is that a difference with the case on the national emission ceiling? But that's something for the question time later on. So we are just 10 minutes, no, only 8 minutes late. So we will resume in 15 minutes, so a little bit before 11:30, so 11:28, we will restart our conference with a presentation by Thomas Weber. And now you can enjoy a digital coffee break, which means that you have to look yourself for something to drink. So see you within 15 minutes. Thank you. So dear colleagues, I propose that we start again with our conference. I hope you enjoyed a nice coffee or tea break. And now I'd like to present to you Mr. Thomas Weber. He is the head of the Division of Installation-Based Air Pollution Control and Ambient Air Quality with the Environmental Ministry of Germany. So the federal Ministry of the Environment. So the floor is yours for a presentation of the German experiences with this issue. Thank you.
Yeah, thank you very much, and many thanks for the invitation to speak at this conference. As you said, my presentation is about current air quality issues from the perspective of the Environment Ministry. And today I won't be talking about so much about court cases, but rather about policy aspects of air quality. Next slide, please. I think you have seen this type of slide a couple of times before. I just want to mention a few things. The emissions, that means the pollutants emitted from chimneys or exhausts, they are transported away from there and undergo chemical transformations before they affect humans or ecosystems in the form of emissions. This means the air you breathe. Most of the EU legislation in that context is emission-based, and In most cases, it is emission source legislation. The focus of my presentation today is going to be two pieces of legislation. On the one hand, on the emission side, it's the NEC directive on emission ceilings, and on the emission side, the ambient air quality directive. Next slide, please. Before I go into these two directives, I want to say a couple of words about the responsibilities of different authorities in Germany at national, regional, and local level. So on the federal level, you have in the form of the federal government, on the one hand, the Environment Ministry, which is responsible in terms of air quality, mainly for policy making and implementation, for example, implementing EU directives into national legislation. There is also very important roles for the Federal Environment Agency, especially when it comes to reporting to the European Commission. Within the NEC directive, also calculating emissions, except for agriculture, and they also do collect air quality data from the different regions and then report it to the European Commission. And of course, they also do the departmental research in the area of air quality. Especially for agricultural emissions, there is also the Thünen Institute involved, and a scientific institute in the scope of the Agricultural Ministry. Then on state level, you have different types of authorities, which are also involved via the Chamber Bundesrat in the federal legislation, but are also mainly concerned with enforcement. That means air quality monitoring and air pollution control planning. And the involvement of towns and municipalities, it varies a bit from state to state. Some states, they have delegated part of the authority from state level to the town or municipality level. Next slide, please. So coming to the NEC directive and the National Air Pollution Control plans. Next slide. Here you can see an overview over the new NEC directive from 2016, which was implemented in the 43rd National Emission Protection Regulation in 2018. The NEC directive covers more or less the sum of the national emissions of the pollutants you see on the right-hand side. It's reduction obligations addressed to 5 pollutants in total, and you have obligations for the time frame from 2020 to 29. And then obligations from 2030 onwards. And the reduction percentages refer to a base year 2005. In order to demonstrate the plans of the national government, how they want to reach these obligations. Every member state has to submit a national air pollution control program every 4 years, or at least every 4 years, to the European Commission. And the first program in Germany was adopted on 22nd May last year and submitted to the European Commission. One thing about the pollutants you see on the right-hand side, I have displayed also a graph how the development was for primary PM2.5 emissions in the last decades. You see it went down substantially. One thing I'd like to mention, nevertheless, even though there is primary PM2.5 mentioned specifically as a pollutant, you also have chemical reactions ongoing for other pollutants that are emitted, and some of these pollutants are also precursors for PM2.5. That means if you are emitting, for example, SO2 NOx or ammonia, then they function as precursors and also contribute to the PM 2.5 concentration. So on top of the primary PM 2.5, we have more pollutants that increase the problems on the ground on the side of the emission. And the NEC directive aims to reduce both the primary emissions and the precursor emissions of PM 2.5, so has a specific focus on this pollutant. Next slide, please. The main content of the NAPCP, our National Air Pollution Control Program, is first of all the development of the national emissions in the past for the different pollutants, and then focusing on emission projections for the time frame 2020 to 2030 with two different scenarios. The first scenario is obligatory in all cases. It's the so-called with measures scenario, where member states are required to project the emissions in the future based on assumptions how emissions would evolve using only measures already adopted in the member state and already required. In cases where these measures are not sufficient to reach the obligations, a so-called with additional measures scenario has to be used as well, including also a list of additional measures needed for compliance with the reduction obligations. And finally, there is also an assessment of the impact on air quality with background modeling. Next slide, please. A few words on the calculation of the national emissions. This is explained in detail in various guidance documents, and I don't want to go into very much detail. I just want to explain the principle. The emissions that are included for every sector and subsector, they are calculated basically always as a product of a so-called activity rate and an emission factor. And activity rates can, for example, be fuel consumption of cars in terajoules, can be number of animals in given units, or it can be a quantity of product used in kilograms, and there are various more possibilities. And the emission factors can be obtained on the one hand by measurement results, but in some cases there is no continuous monitoring and measurement. In this case, other options come into play, like, for example, modeling or expert calculations or estimations on the basis of qualified assumptions. So the quality varies also in the different categories, and as this guidance is also updated from time to time, also the calculation has to be updated as well. Next slide. On this slide, you see an overview of the with additional measures scenario for compliance with the NEC directive in Germany. I've shown this only for the 2030 timeframe, because for 2020 we do already have compliance with the with measures scenario. But in 2030, there is, as you see on the top of the diagram, only for one pollutant compliance reached in the with measures scenario, so with the already adopted measures, and this is the non-methane volatile organic compounds. For the other four pollutants, we do need additional measures. So going a little bit into more detail, as you can see, the additional measures, there is a very large block of climate change mitigation measures, which is taken into account here. And these climate change mitigation measures, particularly the phase out of the electricity generation of coal, delivers quite a large co-benefit, especially for NOx, SO2 and PM 2.5 here. Then we have the national implementation of the medium combustion plant directive, which is particularly effective in terms of NOx emissions. And in the case of ammonia, which is a pollutant which is very agriculture related, there is a package of a total of 14 measures in the area of agriculture, which I will mention later on in a little bit more detail. And with these measures in combined, we will reach the NEC obligations. Next slide, please. As in the with additional measures scenario, there is also contributions which were not directly visible. That's why I'm trying to show you this in that specific diagram here. And when you look at the left-hand side, I like to focus specifically on the transport sector. You see in 2005 in Germany, the road transport had a contribution of 738 kilotons of NOx emissions. And especially due to the Euro standards and the fleet renewal, these NOx emissions will go down to 110 kilotons in 2030. And similar on the right-hand side, you see also in the field of road transport, this is decreasing from 36 kilotons in 2005 to 14 kilotons, especially also due to European emission regulations for road vehicles. Another aspect that you see is on the right-hand side for PM emissions is the contribution of residential combustion. The share of residential combustion is significantly increasing to 2030 and will become a more important player, which I will also mention on a later slide again in more detail. Next slide, please. Here you see a rough overview of the phase out of the coal-based electricity production in Germany. So the phase out is planned to end at the latest by 2038. And with this measure, we expect major contributions to NOx, SO2 and PM2.5 reduction. If there is refuse planned also in 3 years that are mentioned on the left-hand side, and each time it has to be checked whether or not the final end date can be advanced a little bit. So there might be even more reductions by 2030 in case one of these refuse leads to changes in the trajectory. Next slide, please. I have mentioned the co-benefits that a lot of the climate change mitigation measures deliver in the area of air quality. There is also one specific area where we actually have incentives from climate change, and this is particularly for bioenergy as a greenhouse gas reduction measure. But in this particular area, we do not face co-benefits, but rather trade-offs with air pollution, because especially in the area of solid fuel biomass combustion, that means combustion of wood, the PM2.5 emissions are significantly higher compared to, for example, compressed natural gas boilers. So if you have a wood-based heating system at home, then this would deliver about 500 to 800 times higher PM2.5 emissions. And this is already calculated with somewhat more ambitious national standards that we have in Germany. As these figures are so high, we had one measure in our National Air Pollution Control Program to maintain more ambitious national standards for solid fuel boilers in Germany. And government has applied for the retention of these standards nationally. And this year, the Commission has approved that Germany can maintain these standards as they are needed for compliance with the NEC directive, and will probably later on also be needed for a future ambient air quality directive. Nevertheless, we think continuous monitoring of the number of solid fuel boilers is necessary, because a large increase of solid fuel boilers would certainly be a compliance risk for the NEC directive later on. And in this spirit, also the Council, the Environment Council, in its conclusions on improved air quality, mentioned that new emission requirements under the Eco-Design Directive, including for heaters and boilers, should contribute to continued coherence and synergies, and should avoid trade-offs, such as in the case of biomass. And I think this is particularly important to keep in mind, both for the NEC directive, but also for future ambient air quality standards. Next slide, please. Here you can see the PM2.5 emissions of transport, and there have been significant reductions in the past. You see the curve from 2005 to 2016. And particularly the emissions of exhaust, which were at 35 kilotons in 2005, went significantly down to 2016 to 15 kilotons, and will continue to go down in the future when there are more cars with particulate filter on the streets and the older cars are renewed. But you have still this block, which is indicated by orange brackets, which are abrasive emissions. That means emissions from brakes, tires, and also from street. And while this block more or less stayed constant, and also is not expected to be reduced in anywhere in the near future due to technical challenges, this will have a higher relative importance in the future. So the focus here will shift also a little bit. There are research projects addressing this, and we hope also that at least part of this can be also addressed in future legislation. Next slide, please. I've mentioned the ammonia emissions from agriculture before in the overview. While there has been a substantial decrease in other pollutants covered by the NEC directive, there hasn't been such an effect in the case of ammonia. On the right-hand side, you see the curve in yellow. This is the development of ammonia emissions in the past for Germany. The curve would probably look very similar if you would display the whole EU emissions. So ammonia is an issue, I think, quite widespread. And we think in terms of air quality, it's particularly important as it is a precursor of PM concentrations in cities. There are calculations, of course, it's differing from city to city, and depending on how you're doing your modeling, but the effect can be quite high. So up to 30 to 50% of the PM concentrations in cities can be due to agricultural emissions that occur outside the cities. And in the case of ammonia, if you're looking at the emission statistics, 95% of the ammonia emissions in 2016 came to agriculture. So, for example, from spreading of organic fertilizers, mineral fertilizers, or from fermentation residues of biogas plants. And therefore, our National Air Pollution Control Program includes a total of 14 agricultural measures to address this issue, to reduce the ammonia emissions substantially to 2030. Next slide, please. So moving forward to the ambient air quality directive. Next slide. Also here, we've seen significant improvements of air quality in the past decades. On the right-hand side, I displayed an example for the average PM2.5 concentrations at selected stations in Germany, which went down quite a bit. But nevertheless, as was also pointed out yesterday by several speakers, that air pollution is still a major health risk in Europe, and it affects strongly the burden of disease from various diseases like stroke or heart disease, but also many other diseases more. In a situation in Germany is following. We do comply with PM limit values at all stations since 2018. We have had a few exceedances before that at a few selected stations, industrial stations, but we are in full compliance now since 2018. But we do still have exceedances of NO2 annual mean limit value of 40 micrograms per cubic meter. And this is exceeded in 25 cities in 2019. The number of cities went down quite a bit in the last few years as there have been substantial reductions. So the situation is improving. And when you're looking at the origin of this issue, at what is the main cause, then it is the high NOx emissions of diesel passenger vehicles. Next slide, please. To go a bit more into detail about that, the share of this problem is quite high. The Environment Agency in Germany estimates it around 70%. Yesterday, you've seen figures from, I think, the EEA, which were between 60 and 80%. Of course, this depends also on the specific situation you're talking about, the specific city, as the fleet composition is different everywhere. This high contribution is there, even though in Germany the share of diesel cars is with 33%, quite low in the European comparison. It's in the lower third of member states approximately. But the problem is, and that you see in the lower table and on the chart on the right-hand side, the emissions of passenger diesel cars, the real-world emissions are much, much higher on average. This is not some single cars which are displayed here, but this is an average. These are average real-world emissions of diesel passenger cars of the different Euro standards. So they're about 4 to 8 times higher than allowed by the emission standards. These numbers, they were assessed by several European environmental agencies. They're doing this regularly over time, and these are the most up-to-date figure. And what you see at the last line of the table is the so-called real driving emission vehicles, the Euro 60 temp vehicles, which came into market from September 2019, or which are binding standards, to be precise, from September 19. And these cars, according to this assessment, emit only 46 milligram of NOx emissions. That means it's about 50 to 20 times less than the older vehicles. And as far as we know, the additional costs of these new cars due to the requirements are quite limited. So it seems to us that this has been a very proportionate measure for NOx reduction. Next slide, please. The fleet renewal is ongoing at the moment. We have seen also fleet renewal in Germany starting substantially a year before it became obligatory in October 2018, which was probably also a little bit due to the discussions about high NO2 concentrations in cities, and also the court cases ongoing with the question of diesel bans being enacted in the city. I think that contributed probably also that these cars were voluntarily purchased before its obligatory date of entry. But you also see that there is a joint effort needed on various levels. And for Germany, the measures that were enacted, you can see on the right-hand side of the slide. So beside the fleet renewal, which I've mentioned, there is also a number of federal level measures, like, for example, the software updates of diesel passenger cars, partly obligatory, partly voluntary software updates. There has been financial support schemes to promote hardware retrofitting for light-duty vehicles and vehicles of regional authorities. The government has also financed the so-called Model City program, which includes particularly support for public transport and also for things like bike lanes or similar aspects. And there is also a private sector funding of hardware retrofitting of diesel passenger vehicle cars, which is currently financed by 2 car manufacturers for cars of their own brands in and around cities with concentrations beyond 50 micrograms per cubic meter. And on the regional level, there are different measures depending on the city. So I just selected a few of them. There are many, many more when you look in the air quality plans of the different regions. So what's quite widespread is promotion of alternative modes of transport, so public transport, bike lanes, something like that. There is also a tendency that dedicated lanes limited to specific mode of transport are started and in heavily on roads with heavy traffic. Sometimes there are so-called gatekeeper traffic lights where the number of vehicles allowed to enter a specific street can be limited. And of course, there is also driving bans in some cities. I think there is one city which has a zone for specifically dedicated to NO2. Other cities which have bans that are limited to certain streets which are specifically affected by high NO2 concentrations. And these bans were usually also, that has been mentioned before in other presentations, an issue in court cases. We expect further NO2 reductions in the future with these measures, and also in some cities there might be additional measures still needed for full compliance. So next slide, please. So looking a little bit more into the future, the European Commission has announced in its Green Deal communication that it intends to revise the Ambient Air Quality Directive with a particular aim to more closely align it with the WHO guidelines. On the right-hand side, you see this is a table out of the fitness check of the European Commission. You see the comparison chart between the WHO guideline values and the EU air quality standards. And in red, the air quality standards are flagged, which are still below in the level of ambition, still below the WHO guidelines. So there is on several pollutants room for improvement, and this is particularly the case for the particulate matter emissions and concentrations, which you see at the top 4 lines in the table. At the moment, there is an update of the WHO outdoor air quality guidelines ongoing, and we expect new guidelines to be published sometime during next year. Next slide, please. So as there will be many aspects when the directive is going to be revised that have to be discussed. Among many things, certainly the level of ambition that the new directive aims at. But there is one particular thing that I would like to draw your attention to here, and this is the governance aspect of a future directive. As I've shown before, currently in the ambient air quality directive, member states and regions are responsible for compliance with the directive. But there is an issue that in future reduction options for member states and regions are a bit more limited than has been the case before. And this is due to two main issues. The one issue that I think Martin Adams mentioned that yesterday as well, pollutant concentrations, they are not only affected by the local emissions, but also by long-range transport of pollutants. So a large share of the relevant emission sources that are affecting local concentrations, they are emitted outside of the jurisdiction of the responsible entities or of the responsible region or the responsible town. And the extent varies, of course, depending on the pollutant, the size of the member state or the region you're talking about. But it is an issue with several pollutants. Another issue that limits the possibilities of the member state is that emission source legislation is mostly adopted on the EU level now. So they cannot change, in many cases, cannot change these ambition levels and deviate from the EU legislation. So these points are points for consideration in the future structure of a directive. On the right-hand side, you see an image which displays schematically the influence of the background. You have the rural background, you have urban background, and you have peak city and traffic emissions, which are much higher than these background emissions. Next slide, please. To give you some examples for this long-range transport and why this is so important, I think a very good example for this is ground-level ozone. Here, ozone is a specific pollutant because it's not emitted, but it's a product of complex chemical reactions of several precursors, like, for example, methane. So it's a secondary pollutant. Which has also a very high sensitivity to meteorological conditions, in particular sunlight. So you're seeing ozone episodes specifically in hot summers. Ozone and also some of its precursors have very long lifetimes. In case of ozone, it's up to several weeks. So the pollutant, once it's formed, it can be transported over very, very long distances, and it's usually not formed at the place where it poses a problem in terms of high concentration or an exceedance. There is a similar situation also for particulate matter. Also fine particles, which are smaller than 1 micrometer, can be transported over hundreds and thousands of kilometers. Also here you have the problem that the emission sources are outside the jurisdiction of some regions in many cases. And I've mentioned before, also a substantial share of the fine particle concentration is due to ammonia emissions in agriculture, which is usually also emitted outside or sometimes far outside the cities affected by the consequences of these emissions. Next slide, please. I've shown you before, which you see on the upper right-hand side, the formula for the emission calculation and for the NEC directive. But of course, if you're considering emission reductions under the Ambient Air Quality Directive, then also you have to identify the relevant emission sources, and afterwards you have to decide whether you want to reduce the emission factor or if you want to reduce the activity rate. Reducing the emission factor is mainly determined by emission source legislation, which is now usually adopted at EU level. You see a lot of examples on the lower right-hand side in the orange box. So you have emission source legislation for passenger vehicles, for light and heavy duty vehicles, non-road mobile machinery. There is also the eco-design requirements for the solid fuel boilers, for example. And then you have different kinds of installation-based directives on the EU level. And even in cases like the last two mentioned here, where you in theory could have more ambitious standards on the at the member state level, this is something that is very rarely done, also very rarely done in member states which you consider as the more environmentally ambitious ones, because such higher standards might also be considered as a competitive disadvantage in terms of economic aspects. So on a regional level, it most often comes down to reducing activity rates due to lack of legislative power on the emission factors. And looking at activity rates, you are talking about driving bans, for example, ban of solid fuel biomass combustion in private households, or restrictions on the number of animals. So these are all measures which are usually less proportionate and associated with higher costs compared to possibilities that you have with emission source legislation. So therefore, and I think this was also mentioned yesterday, it is very important that in a future directive there is a joint responsibility and joint action is needed on all levels, particularly if ambitious standards, ambient air quality standards are envisaged, because in this case you definitely need a joint action on the several levels mentioned, and this was also stressed by the Council conclusions in March this year. The Council specifically asked that the air quality objectives should be fully reflected in the EU emission source legislation. Next slide, please. So concluding from this, there have been significant improvements achieved in the area of air quality, but air pollution is still a major health risk in Europe, and therefore, from our view, further reductions are necessary in the future. But there will be certainly a shift of focus in terms of source categories, mainly due to the successful emission reductions that have been achieved. And we also see a need for joint action on all levels to be considered in the government structure of future ambient air quality legislation. Next slide. So thank you very much. I'm open to question, and also you're very welcome to contact me bilaterally if you have any further questions after this conference.
Thank you very much, Thomas Weber, for giving us insight in the wide range of challenges that European Union air law is posing for the member states and the environmental administrations. So thank you very much. We have still maybe only 10 minutes left for our discussion. I don't know if there are questions, additional questions from the room. Yes, I think from Karen de Roo, that's more or less the same question I already have indicated after the first presentations. So it's, I understood from the report of Katalin that on the national level there are variations in the view what's the possible impact of air quality standards, ambient air quality standards on permitting, let's say, projects in, let's say, non-attainment areas. So suppose that, for example, in an environmental impact assessment for a development, a project development, one finds out that when such a project would be in operation, then the non-attainment problem will not diminish, but will be a greater one. So I don't know if you can, Katalin, give us some more details about the differences in the jurisprudence on the national level, and maybe a question for Christophe. Till now, I think the Court of Justice has not had the opportunity to look in that. So it has looked in the national emission ceilings and the impact on projects, but not on the air quality. So please, Katalin, can you give us some more information on that?
Certainly. So I think that those of you who are interested in this topic maybe should consult the report of the Czech Republic, because that was the national report which elaborated the most on the exact procedure of such cases, because Czech law allows individuals to challenge an individual project in case the permit or the operation of the installation would lead to an infringement of limit values. So what is interesting here is that even the Czech law, which allows such a possibility, or the jurisprudence developed based on that law, that's very elaborate and complex criteria, which, according to the national report, in fact narrows down pretty much the prospects of success of such challenges. So we see that the court must do some balancing and must take it into account that sensitive economic interests are at play in such challenges. First, individuals can only take a permit to the court if they raised such complaints in the administrative procedure. Second, the court would balance the public benefits of the economic project against the environmental impacts. They would third make a proportionality assessment. The challenge of the individual can only succeed if the emissions are disproportionate to the local circumstances. And what is important here is that the court cannot make this comparison with locations where such industrial activity is not ongoing. So you cannot, so the counterfactual situation cannot be a location where there is no industrial emission whatsoever. And lastly, the court would also take into consideration the period over which the facilities were already active, which I suppose mean that incumbent players would have some advantages. So my point here is that maybe it's not surprising that only just a few national laws allow for such a possibility, and even if those that they allow set very high criteria, because it is a complex and sensitive matter. I mean, my additional thought on the matter is that if we were to allow a national court to deny permit, or in fact, if we would require them to deny permits in such cases, then this could raise sensitive issues because would give advantage to incumbent polluters. And so this is something that the courts should be and the authorities should be aware. So based on the national reports, I think this is all I can say. The language of the directive does not compel national authorities to deny the permit, and only certain national laws entertain such a possibility. And the judicial practice even there seems to be quite restrictive.
Christophe, do you have some additional thoughts about this problem?
Yes, I think the most important point is that we have the EIA directive, which requires the identification of the problem. If it isn't identified, then this would, in my opinion, be a procedural flaw which could be advanced against the project's permit. At the very least, once this problem is identified, then and if there is a breach, or a breach is to be expected, then of course the air quality plan should immediately be developed or adapted. This doesn't directly do anything about the project, but if the problem is big enough, I would probably be tempted to think about whether an action against the project is possible in order to avoid that the future plan is prejudiced this way. Imagine you have a definite permit, and with this definite permit, it wouldn't be possible to achieve the limit value, or it would be extremely difficult to achieve the limit values because you had to prevent anybody else from using heating in the area. Then of course there we would be in the area of limits of discretion, and we would also be in an area where we might want to have interim relief from the courts before the permit is issued, or at least once the permit is issued, before it becomes definite, to avoid that such a prejudice is developing. But there we are already in an area where the Court of Justice has not yet had to deal with it, and of course these would probably be edge cases. I think in most of the cases that rise in reality, we wouldn't probably be in such an extreme situation, and therefore they might have to be dealt with differently. But again, let me repeat, the important bit is the EIA identifies the problem, and then we would have the authorities that would deal with it would have to try to come to some solution to the problem.
Okay, thank you. There is also a question for Thomas Weber from Director Manfredi. So you mentioned that to obtain the ambitious objectives in terms of results, we have the source-directed legislations, which is set mostly on the European level. And you mentioned that maybe some of them would be not sufficient ambitious to come to the ambitious results. So, and the question is, do you have clear ideas about which of those legislations, source-directed legislations, should be in the framework, for example, of the Green Deal, be reviewed and made probably more ambitious? So please.
Yes, thank you. I think the question which specific pieces of legislations have to be revised and what emission standards have to be achieved depends largely on the question of the future ambient air quality standards that the Commission is intending to propose, and also in this case certainly on the new WHO guidelines that we expect next year. I think what is very likely to expect is that there will be improvements for particulate matter, because there are quite large differences between the current WHO standards and EU ambient air quality standards. And we also know there are still health effects even below the WHO standards. So I think there is room for improvement and looking to particulate matter. One issue that we are concerned about from the air quality side is are the residential combustion of wood or solid fuels in general, but coal I think is going to be less an issue in the future. It's going to be rather wood with a view to climate change, and there are incentive schemes promoting this type of system for either for a heating system at home, or a lot of houses in Germany now, and I think also in many other member states, they have single room heaters, like so open chimneys, for example. And these systems, they have very high particulate matter emissions. I've shown you the figures for the German legislation, which is somewhat more ambitious than the EU current EU eco-design requirements. So it's 500 to 800 times for the solid fuel boilers higher, for wood boilers higher than for the compressed natural gas boilers. And this is an area where the eco-design regulations fully harmonize the standards for products sold in Europe. So member states couldn't be more ambitious in that area. And I think if we want to move forward substantially with particulate matter standards, I think this is an area where we would need more ambitious standards, both for the boilers, but also for the stoves or single room heaters in order to improve the situation for compliance in the future, especially as we have to expect that climate change incentives will increase in the future, because buildings, CO2 reduction in buildings is a particular challenge, and there are limited options available. There usually, besides insulating the buildings better, if you want to change the energy you're heating with it, you can either choose biomass, which has the negative trade-offs I mentioned, or you can choose heat pumps, which are much more expensive than the biomass. So I think there is quite a likelihood that we will see more of these biomass heaters in the future, and I think this is an area we need to look at. And maybe one point to add on top of that. Currently, the legislation looks like it has been the case for cars only at the so-called type approval. So you have a test procedure to see how much is emitted from these boilers, but they don't necessarily reflect the real emissions of these boilers in the future. With the automatic heating systems, I think they might be much more closely aligned with the type approval. But if you look at single room stoves, where every person can kind of puts its wood there himself and has a lot of influence, and also the heat, the air that goes into the oven is kind of controlled by the person individually. There's a lot of room for suboptimal use of these devices, and so you might face even higher emissions than in the figure that I've displayed. And I think these real emissions would also be an area where I think it would be very good if future EU legislation would address this.
Thank you very much. Unfortunately, our time is over, so I suppose that we have still a lot of material to discuss, but we have to close our webinar, our conference. So I'd like to thank all the panelists for their contributions, and I suppose when there are further questions, people can contact you directly for one or another specific question to raise. So thank you very much. I thank also our participants who have attended the webinar or will attend, because it was recorded and it will be published on our website. So, and now I invite the non-members of the forum to leave the webinar, because now we will have a general assembly meeting. So thank you very much.